May please, my lord. My lord, I beg to mention item number 9, ma'am. My lord, kindly meta में बेजन पढ़ा थे. Leading counsel is out of station, ma'am. D. Kamduk.
Yeah, for the petitioner.
Petitioner, ma'am.
There is private respondent is also there. Legal aid counsel. No objection. Mr.
M. Ratan.
Learning counsel. Some Mr. The leading counsel is out of station. Therefore, pray for of the matter for the date to which the learning counsel hearing on behalf of the respondent has no objection. Page break for comma when
3 weeks after.
this is matter after 3 weeks.
But my lord, interim is there that may be continued, ma'am.
There is interim.
Yes, my lord.
The interim order passed earlier shall continue till the next date of wisdom.
Deeply obliged.
Okay. His name, legal aid counsel. Okay. Mr. Kenjini, legal aid counsel. And Miss Gini, additional EP for the state, and Mr. Kenjini, legal aid counsel for the private respondent has no objection. Yes.
My lord, I beg to mention item number 18 for adjournment, my lord.
1-8.
1-8, my lord. 18.
Why?
The file seems to have been misplaced, my lord.
Okay. Okay, Mr. M. Party, counsel for the praise for adjournment of the matter. For
After a vacation, my lord. After vacation, 4 weeks.
to be listed after the ensuing ensuing puja vacation. With Mr. T.F. Then additional PP has no objection. Prayer allowed. List is matter after 4 weeks. Okay.
Obliged.
Lordship, I wish to mention item number 17. I'm appealing on behalf of Deepangi. Community Council order station due to some medical emergency. I beg to mention item number 17. Your
Yes, for what?
Community Council Deepangi is out of station for medical emergency.
Mr.
Sita Jo.
Similar order. The learning council, some state, the conducting council, Mr. B. is in this post. Therefore, pray for adjournment of the matter for
2 weeks.
the praise of love. List is matter after 2 weeks.
Much obliged.
Okay.
Item number 1.
May I, Your Lordship?
Yes.
Your Lordship, this is an anticipatory bail under section 482 of BNSS, Your Lordship. Your Lordship, the applicant is a government servant officer. He is presently serving as a ranger forest officer, posted at Rowing, Your Lordship. Your Lordship, on the perusal of an FIR, there is no specific allegation against the applicant. Also, the name of an applicant is not mentioned in the FIR. If Your Lordship may refer to annexure number 4 at page number 24, this is an FIR.
Your bail has been rejected.
Earlier, we have
on perusal of the records, your bail was rejected.
Yes, Your Lordship. Earlier, we have approached before Special Judge Pokso.
Yes, that is right.
Yes, Your Lordship. If Your Lordship may refer to that order, which is at page number 19. May I read, Your Lordship?
Yes.
Your Lordship, if I may read the only the relevant portion, which is at page number 21, that how the court has considered and then viewed that on what ground the bail has been rejected, Your Lordship. May I read, Your Lordship?
Yes, please.
I have perused the CD placed for courts. Prima facie, if material in CD is considered, I am in the concerned with submission of London Council for the applicant that prosecutors had attained majority at the time of offence. Be that as is may, the material in CD suggested that the accused applicant Kabuk Lego had taken service from the accused Kegul Kamno and Kapong Sora, wherein despite of the prosecutor's objects, accused Kabak Lego had enjoyed the physical relationship with the prosecutors. Thus, the offence under section 64A BNS is prima facie found established against person. Your Lordship, on the ground that there was as per the proposal of an CD, there was only an allegation that it has been stated that he has obtained a physical relationship from the victim. However, the court has specifically mentioned that the victim has attained at the age of major, and the allegation is only based on one transaction which was established by the IO, which was one transaction of 6,400 was made from the applicant account to the alleged accused. Your Lordship. If Your Lordship may refer to my paragraph number 5 of my plaint, where I have stated that the reason of transferring amount of 6,400 to an accused, alleged accused, which the name is mentioned in the FIR, that alleged accused was, he being a government employee, he has personally on his government official duty, he has appointed that alleged accused person. He has appointed him.
But this alleged accused is alleged to have been involved in the racket.
Yes, Your Lordship. However, there's a relationship between how this police personnel has created between the alleged accused person and applicant is basically only on one transaction which has been made on. To that effect,
Once the perusal of the record,
yes, Your Lordship.
this was the bail was rejected. Let us call for the
CD, Lord.
CD.
Your Lordship.
So what is the position? What is the status otherwise?
Yes.
Status of the investigation? FIR was lodged when?
It was closed. 30th.
Okay, July.
Yes, Your Lordship.
Okay.
And also, Your Lordship,
Okay.
in this case, Your Lordship,
Hmm.
on the same footing, there are an alleged accused who has been named as a customer.
Mhm.
And there is an information and there is a record that those alleged accused person has been released from the police station on PR bond. On the
You have the record?
position. Yes, Your Lordship. This is statement which I have written on my plane.
No, let us see the records then.
So therefore,
Yes,
Your
Harry,
Lordship,
let us see if the person, similarly situated person have been.
Yes, Your
released.
Lordship.
Let us
So-
see.
so in that case, Your Lordship, CD may be called for and then separate this specific record, which have been stated that certain other 17
That
accused.
also is expected to be available in the case, along with the case, Harry.
Your
Isn't
It should be, otherwise, if it's even not available, if they have a record of the same, that can be placed in additional affidavit by them.
Right.
Otherwise, Your Lordship, that this may be given that those, if they are released, so that record may also be called for, Your Lordship.
Hard, Mr.
Jay Sri.
J. Sering, non-counsel for the petitioner. Sir, this is an application filed under section 482 of the BNSS 2022, seeking granting of pre-arrest bail, apprehending his arrest in connection with drawing PS case number 51/2025 under section 140 within bracket 4/3 within bracket 3, stroke 144 within bracket 1, stroke 64 within bracket 1 of the BNSS, read with section 6 of POCSO Act 2012. Stop. Ms. Jeannie, additional PP, appear on behalf of the appear and accept notice on behalf of the state respondent. Stop. Call for the, will be a scan copy?
Yes.
Scan copy of the case along with the status report and the records of the release of the co-accused, if any. Release of the co-accused
Yes, sir.
by the police, if any. Okay, start. The petitioner shall take steps upon the private respondent by a registered post. This will go by,
Your Lordship can, they can take steps through the office of the public prosecutor.
okay, through the office of the public prosecutor to be routed for the registry.
Yes.
Okay,
Registry, this entire thing is made by the registry, they only take steps through us, Your Lordship. The,
okay,
concerned jurisdictional police station.
okay. Through the concerned police station. Okay. To be served through the concerned police station.
Your Lordship, I may also pray for an interim.
So
Since-
it may not be, because we need to see, because there is serious allegation against. you, and then the court has made an observation that there is a serious allegation against you. There is a racket which involves with the society.
Yes.
Please this matter when,
you will-
Because since the notice has also to be.
yes, private respondent
If I may on 17th,
17. Okay, please this matter again on 17.
Highly obliged.
Item number 2,
My pleasure.
Yeah.
Lordship, in this case, this FIR is filed alleging the violation of the contract agreement entered between the parties. The contract agreement is in connection with the business running for the petrol pump depot at the Dapo region. And here present applicant is only witness to the agreement.
Who is witness?
This present applicant is witness to the agreement that was entered between the parties. So main party of this agreement was arrested by the Dapo police. So now,
Already arrested.
yes, now witness who stood as a witness that agreement, the police is hanging after him for arrest. So may I
What
read
is
the
it?
FIR?
Witness, only witness, no role,
Yes,
no role.
no role. I have no any role, no any
Where do we
connection.
find your name as a
Uh,
witness?
Page number 16, 16 is the
Your name
agreement.
is not there in the FIR. You are not the
Yes,
name.
my
FIR.
my name is there in the FIR. So
Where do we find
uh,
your name?
let me read the FIR. Page number 10 is the FIR. To the officer in charge, OC, police
Okay, come
station,
straight to one.
Dapo.
The allegation.
The FIR subject FIR against Sri Kondan Mal Mahaswari Elijah Kondan Mal Bajaj, son of so and so, so and so, so and so. That is main accused person, the prime
Oh,
accused
your
person.
name is also
And Sri Bimal Bajaj, this is me.
there.
Bimal Bajaj, son of so and so. For Beth Energy, forgery. That is only the allegation is labeling for avoiding the tax, that is value-added tax. That is in connection with the deed of agreement entered between the proprietor of MS Subansri Energy Station Dapo region. This main prime accused, this prime accused Kandan Mal is the person who running the petrol pump diffuse petrol pump depot at Dapo region from 2022. But still, the accused, that person is running the depot without any problem. Now here the informant is the husband of the proprietor. The agreement is entered between this prime accused and the proprietor of MS Subansri Energy Station. So let me read the continued FIR. The allegation 1 on 17/5/2022, Sri Bimal Bajaj, the nephew
Email
of,
is you.
yes, nephew of Sri Kandan Mal Mahaswari Elijah Kandan Mal Bajaj, said came to my residence in Tamil Namlo, Itanagar in a white SUV. They approached me to run the said petrol depot on rent, expressing willingness to take it at any cost and citing their experience of running multiple depots in Arunachal and Assam. Sri Bimal Bajaj convinced us that
You are the main.
he would manage operate well his uncle Sri Kondan Mal Mahaswari Elijah Kondan Mal Bajaj would oversee management. Accordingly, with limited knowledge of such business, we agreed and executed of agreement before the executive magistrate Itanagar, so and so, duly signed by the both parties and witnesses. However, in August 2024, we came to know that Sri Kondan Mal Maheswari Kondan Mal Bajaj, being the power of attorney holder, was not paying the mandatory VAT, that value tax, and other government dues since 2022. Despite repeated requests and assurance, he, along with Bimal Bajaj and Sri Ravi Goswami, failed to clear the dues. Shockingly, on 24/1/2025, Sri Kandan Mal, Elijah Kandan Mal Bajaj and his wife absconded from the MS Subansiri Energy Station, leaving behind a huge unpaid tax liability. The matter was reported to Dapore Police PS on the same day. It is surprising that despite such large-scale VAT evasion from 2022 to 2024, the tax department continued to issue C-form without clearance of VAT, due raising question on their role and accountability. This is the allegation. Enclosure deed of agreement, details of C-form and obtained from Superintendent Tax Dapur Region, details of VAT dues, photographs of the absconder Mr. Kandan Malbajaj, other PAN, and copies of Mr. Kandan Malbajaj, Elijah Kandan Malbajari, contact number Sri Kandan so and so, Vijay Bamal so and so, Ravi Goswami so and so. Here, 3 names is mentioned in the FIR. It is pertinent to mention here that Vijay Bamal is the mastermind of the behind this rocket, operating an interstate syndicate of illegal petrol diesel dealing.
Name in the deed of agreement.
Page number 16 is the deed of agreement entered between the proprietor.
Where do we find your name?
Page number 19. Second witness. Bimal Bajaj.
You are the
Two.
one who convinced.
Yes. As per the allegation, I am the person who convinced them to enter the contract agreement.
Yes.
My lord, further that I would like to submit one more things. My name is reflected in the FIR as a witness. I'm not in the party, nor in the
In
partner.
FIR, you are the main. You are one.
Even then, my lord,
For
this FIR is arising out of the contract agreement. This is purely civil dispute.
Contract agreement is because he is having power of attorney, not you.
Yes. And the
But
page
then you are the
number,
main accused.
recently, my lord, that due tax 1 crore 50 lakhs has been deposited in that against the due account.
You have the,
No, that is
where-
deposited by
do you
the,
have any record that the main accused has been already arrested?
yes.
Where?
Page number 15. Annexure 3. Accused person Sri Kundan Mal Mahaswari, age about 64 years, is produced before me today at around 12 p.m. by the police. Seen the following letter, FIR arrest memo, checklist, medical report, etc., forwarded by the IO, Mr. So and so. It appears from the record that above accused was arrested by police on 30/8/2025 at 18 hours for allegedly committing offense under section 316, clause 5, 318, clause 4 BNSS. The accused and satisfied myself that the ground of arrest is intimated to him, and the fact of his arrest is also intimated to his son Sri Niraj Bajaj. No mark of violence is found on his body. This is, my lord, records where showing that the main accused of this case has been arrested.
Yes.
Yesterday may be called for lawsuit or with to ascertain whether the custody interrogation is required or not.
My protection because I have no connected in this case, but my name has been read. So my personal liberty
Land Council
will be
for the
protected.
petitioner. Okay. Ms. El Hage, Land Additional PP, appeared on behalf of the state respondent. So why you have impleaded this other respondent?
Only I have not employed any private. We are only officer in charge and the investigation officer.
So we will represent what, 2 and 3 also.
So yes, also all the, because they are all the parties, so it's
Sure.
that process.
By filing this application under section 482 of BNSS 2023, read with Article 21 of the Constitution of India, the accused applicant is seeking granting of pre-arrest bail, apprehending his arrest in connection with the Procedural. Where have you mentioned the PS case?
In my course,
It's very difficult to find the PS case number. Notes mention where it is supposed to be mentioned. Where have you kept hidden the numbers? It should be in the beginning only.
The page will FIR or page 60. Oh, sorry, FIR number 0060.
PS case number. Where? The Procedural PS case number 6060, 2025. Under section 316. Within bracket 5, stroke 318, within bracket 4. Of BNS 2023. Para. The prediction case is that the accused applicant, along with one, your Bimal was okay. Kundan Mal Maheshwari, alias Kundan Mal Bajaj. Enter into an agreement with the informant to run the multiple depot. Petrol and what depot?
Bharat Petroleum.
Petrol and petrol and what?
Bharat Petroleum Corporation
Okay,
Limited,
Bharat
petrol
Petroleum.
pump retail outlet.
Petrol depot in Arunachal Pradesh and Assam. By executing a deed of agreement. When the agreement was entered
10/05/2022.
on 1/5/2022. The accused, the co-accused Kundan Mal, the accused Kundan Mal Maheshwari, alias Kundan Mal Bajaj, who is the power of attorney holder, is the main accused. No, just a minute. Power of attorney holder was not paying the mandatory VAT and other government dues since 2022. Stop. Despite repeated requests and assurance, the accused, along with the present accused Vimal Bajaj, failed to clear the dues. And ultimately on 24/1/2025, he fled the state, leaving behind unpaid VAT liabilities. Resulting filing of this FIR. Resulting registration of this FIR. Okay. The Land Council for the it is the submission of the Land Council. The Land Council for the petitioner submitted. The petitioner is only the witness and the main accused, Shri Kundan Mal Maheshwari, who is a power of attorney holder, has already arrested by the police. just a minute. The London Council for the petitioner submitted. He is not involved in the matter. He is he has signed only as a witness to the agreement. And the main Sri Kundan Mal Maheshwari, who is a power of attorney holder, has already been arrested by the police staff. However, the police is looking for arresting him. Therefore, we have a reason to believe that the police might arrest him at any time and cause unnecessary harassment. Hence, this bail application start. Issue notice. Since Ms. El Hadjo, accepted notice on behalf of all the respondents, no formal notice issued. Staff call for the scanned copy of the case diary. Staff release this matter. When?
10th of September. 10th
Hmm?
of, 10th of September.
September. In the meantime, comma. In the event of the arrest of the applicant, Sri Bimal Kumar Bajaj, he shall be released on interim anticipatory bail on execution of a bail bond of rupees 1 lakh. 1 lakh. To the satisfaction of the arresting authority. With one lakh, 1 lakh with two surety of like amount. One of who shall be a resident of the state of Arunachal Pradesh, with the further condition that one, we shall appear and he shall cooperate and appear before the IO of the case as been called for.
He will ask Lordship to give a statement before the IO. Appear,
But then when he his statement will be recorded only.
Lordship, actually,
We
we
need
have
to
done
direct.
the case study on 10th, Lordship. Before that, he should appear before the IO to give his statement, if interim is granted, Lordship. Because
Okay.
case study, that
Yeah.
statement will also be recorded.
The further condition that then with the further condition that the accused shall appear before the eye of the case within we are calling on
Yeah,
yes,
on
that-
10, Lordship, yes.
on
Lordship.
10,
Yes, Lordship.
then he should appear before the IO before 10.
Yes, Lordship.
So today is
10, 7, then within before 7, Lordship, before 7th of September. Yeah, okay, okay.
appear before the eye of the case.
On 7th of September. Lordship.
7 is Sunday.
Oh, sorry, Lordship, then 8, Lordship.
1, 2, 3 within 4 days from today.
No.
We'll say we'll fix it on 11. Okay.
Yes, Lordship.
Okay. Within 1, 2, 3, 4, 5 within 5 days from today.
Mhm.
That we shall cooperate and thereafter we shall cooperate and appear before the eye of the case agent that we shall not hamper or tamper with the evidence in any manner, that we shall not leave the state of Arunachal Pradesh without prior permission of the concerned jurisdictional court. Staff of list this matter again on
11th, Lordship.
11th.
Yeah.
Or let us make it 12 only.
Lordship, any time.
Okay, 12.
Obliged.
Highly obliged.
Item number 3,
Yes. Hmm?
Granting of anticipatory treatment.
Okay.
For its well, Lordship will find the FIR at page number 14, detained FIR.
Yes.
May I read?
Yes, please.
I am to inform and state that one Vipul Bora, son of Vipul Bora, Mansipur Road, Lakshminagar, Guwahati, Assam, in the year 2023, West 4, landing money that required urgently to solve the problem of his brother who landed to rail at school to police station since September, and the police is demanding money for release on him. On his request, I took loan from bank and private individuals on interest basis. Thereafter, he assured me that if the money is not refunded, we will set up an educational institute at Guwahati for him. For setting the institute, we will get the institute recognized by the government of Assam, that is Seva Board, CBSE Board, and with some reputed institute. On his he also took money from him again and again. The money was transferred to him in person for the appointment of the research and
as Das mobile number so and so. The major amount was given to Rubul Bora and rest of the amount were given to above named persons on instructions of Rubul Bora by means of Google payment. But after his relative got bail, he has neither set up any institution returning money to me, have requested him on several occasions to set up the educational institution at an early date as promised, but he has neither set up the educational institution nor refunding the money which I have paid, pulling from all sources. He has cheated me by giving false promises. Therefore, by this complaint, I am requesting your office to register this complaint and treat this as an FIR against Sri Rubul Bora as mentioned above. This is the operative part of the FIR, my lord. Now, yeah, outset, my lord. To the surprise of the petitioner, my lord, not even a single penny has been taken by the petitioner as alleged by the accused, my lord. And if your lordship has already seen, my lord, how the stand of the informant is contradicting his own statement, my lord. He is firstly claiming that the accused requested him to requested him for lending of money to solve some problem of who is languishing in jail. And thereafter, he has shifted his stand and he is now claiming that if the money is not refunded, he will set up an educational institution for
Where was the money?
informant.
Where was the money taken?
My lord.
How much amount?
The alleged amount is, my lord,
You were mentioned
19,55,000, which is in the subject
only
of
for obtaining bail for his relative.
my lord. Yes. It is alleged by the accused, my lord, that I have asked some money from the informant for releasing my relative, my lord, from the. This is the allegation made by the informant, my lord. My lord, can that be possible, my lord? It is completely highly improbable story projected by the informant, my lord. Whether it is believable, my lord, and he is
As the
shifting
police,
his stand.
police is demanding money
Yes, my lord.
to fulfill the money demanded by the police.
Yes. For that reason, it is
So
alleged,
police has also been dragged here in this case.
my lord. My lord.
Yes.
Now,
Yes.
lordship, my humble submission is that, my lord, at this stage, protected, I will appear, I will cooperate with the investigating officer, my lord. Till then, my lord, till the returnable date, I may be protected, my lord.
Yes.
Since I have not taken a penny of amount, my lord.
Yes, Mr.
Yes, section 41A of CRPC was invoked. Notice was given to him for appearance.
Yes.
Yes, that is why.
CD may be called for your lawsuit.
Yes, my lord. Case diary may call.
Mr.
Till then, my lord, I may be protected, my lord. Zaman.
Mr.
Zaman, my lord.
MM Zaman. Land Council. Applicant. Also heard Mr. G. Tado, Land Additional PP, Staff Para. This is an application filed under section 482 of the BNSS 2023 by the petitioner seeking grant of pre-arrest bail, apprehending his arrest in connection with Itanagar PS case number 25/2025 under section 420. This is IPC register. When it was registered?
It is registered under the IPC, my lord. It
It is
is,
under IPC.
FIR was lodged on 20th January 25.
So why it is under IPC?
Yes, lordship. That is also a,
So the law did not reach which PS case?
Itanagar,
Itanagar.
Itanagar PS.
Mr. Taro, this is under IPC.
Yes.
Hmm.
It's not.
Probably you may have to apply. That it has to be under BNS.
Yes.
It is equivalent to section 318, lordship.
The prosecution case is that the accused applicant has taken a loan of how much money you said?
It is alleged that 19,55,000
Loan of
is
19
paid
lakhs 55,000.
amount. In the FIR, it is alleged. my lord.
Okay. From the informant on return basis. However, the same has not yet been returned, nor had fulfilled the promise made by the accused applicant at the time of accepting the loan amount from the informant. Based on the written FIR lodged by the informant, the police has registered the above PS case for offense under section 420 IPC staff and also issued notice for his appearance under section 41A within bracket 1.
It is also under CRTC.
This is also CRPC.
Yes.
So this probably the BNS
Yes.
and BNSS has not yet reached this police station. You have to inform that it has.
Yes. Specific remark maybe.
This is also
In the other city. Other cities, please remark.
okay. We'll say the corresponding. What is the corresponding section for 420
420
within
Uh,
bracket? Huh?
should be 318, my lord.
Okay. The within bracket corresponding with 318 of BNSS bracket block, and here also section 41A1. The corresponding BNSS would be
It's 30. If I'm not wrong.
35,
Close.
35, close, close,
Close to.
close to of BNSS. Okay. The land counsel for the petitioner submits that he is innocent of all the allegations made in the above FIR. The police has already issued notice for his appearance under section 41A1 CRPC within bracket corresponding with section 35 clause 2 of the NSS. He has a reasonable apprehension that he may be arrested by the police. Hence this application seeking pre-arrest staff are call for the scanned copy of the case diary the PS case number 25, the PS case number 25, 2025. Staff issue notice since Mr. Tado has accepted the notice on behalf of, Mr. Tado additional PP is present and accepted notice on behalf of the state staff. List this matter when Mr.
Okay, till then some protection may be given, my lord.
When can we fix?
Can be on 12, my lord.
11? Okay,
On 12, my lord.
12, okay,
On 12.
12. Huh? Kara. In the meantime, it is provided that in the event of the arrest of the accused, what is his name?
Rubul Bora, my lord.
Bora, Rubul Bora, in connection with the above PS case number 25 of 2025, he shall be released on interim anticipatory bail on execution of a bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the arresting authority, with the further condition that he shall appear before the eye of the case as and when called for. With the further condition that he shall appear before the eye of the case within 5 days from and give his statement. Okay?
It is 35 clause 3 euros.
Hmm?
35 clause 3.
Or close 35 close 3. Huh? Okay.
Highly obliged, my lord.
That we shall not tamper with the evidence in any manner. Okay. That he shall not leave the jurisdictional court. So he should not leave the state without prior permission of the jurisdictional court. Okay.
I'm deeply
Is this matter on? Okay.
Public.
Item number 4.
May I please, Lordship?
Yeah.
Lordship, in present effort, there are altogether 12 alleged accused persons
Is
named.
it similar to the
Yes, only this, the now present applicant is the last. 11 has been granted by this honorable court in interim protection. He is the last person in by name in effort.
by name?
Yes, altogether 12 in
It is
effort.
similar case,
Yes.
similar with the already passed. Okay.
Bell,
Yesterday,
President Bell,
and they
One,
will
one.
yesterday. Okay.
I can
And
provide.
only the name will change.
Yes.
Yukar Sanjay.
Yes,
The petitioner will be Yukar Sanjay. Okay. So this was fixed on when it was to be listed?
after 2 weeks.
After 2 weeks.
Yes.
We have not fixed the date.
Not fixed it.
Then can we fix the date? Because in all other cases,
Yes.
not yet fixed.
Yes, that can.
I think then we'll fix and then all will come on the same day.
Yeah.
Then after 2 weeks means it will be.
It's
Okay,
on
next, the
16,
third week,
17,
then
and
we'll fix it on 17 or what?
yes, Lordship.
We'll fix it. 17, I think on 17 it will complete 2 weeks,
Yes.
isn't it? Okay, we'll fix it this matter again on 17 September. Okay, similar order. Okay.
Over.
Hmm.
Then item number 5, Lordship. From the same effort, but my name is not there. I'm apprehension because we are from the same clan. My name is not in effort.
But in the order, probably we have not mentioned that you are the named accused in the FIR. We have not mentioned.
Yes, my name is not mentioned in effort.
Okay,
I'm apprehension because we are from the same clan. So
and then a police. Okay, this is also similar orders. We have not mentioned, probably we have not mentioned that
my name.
since my name is mentioned in the, we did not mention
Yes,
in the
in
order.
item number 5, my name is not in effort, but I'm apprehension because we are from the same
Okay.
clan.
Okay, but in other order also, we have not mentioned that you are named.
No,
accused
in
in
other, my names are there.
Okay.
Till
Then-
item 4,
Hmm.
bail application, right?
Okay,
begin
then in
from,
that case, only one sentence, although his name has not been mentioned in that. However, since he is also a member of the community, a member of the
same clan.
same clan, he is the accused applicant is apprehending his arrest.
Yes.
Same clan, and the police is looking after him. He is apprehending his, well, he has an apprehension that the police might arrest him at any point of time. Okay,
Same
Okay.
order.
similar order.
Okay. Obliged.
Same condition, huh?
Yes.
It
Obliged.
was 20,000.
Yes.
Yes.
Item number 6.
May I please, my lord?
Yes.
My lord, this the petition is for quashing of FIR dated 28/9/2016, launched by my wife, my lord. So now we are jointly filing this criminal petition for quashing of FIR, my lord.
Where do we find the FIR? Page
My
where?
lord, FIR is page number, page number 12, my lord, annexure 1.
They are wife and husband.
Yes, my lord.
Now, what is the position?
Petition is for
What is the position now?
my lord. Now
It was way back in 2016.
yes, my lord.
What is the present
Trial
status?
trial has already begun before the learned court of
This
JMS.
case?
Yes, my lord.
Okay.
So only my wife has been examined so far. Only one witness has been examined, madam. Now, since 2016, we are living separately. So subsequently, we have settled the matter with mutual deed of agreement.
This is joint petition.
Yes, my lord. And also subsequently, my wife, she has obtained decree of divorce from the Honorable District and
Filed
Session
by,
of UP.
filed by the respondent.
Yes, my lord. This is jointly filed by my
Okay, sorry. Filed
husband
by
and
your
wife. my lord. Now they are ex-husband and wife. my lord. So my lord is praying for quashing of FIR since they have mutually resolved the matter. And now we are also
Where
legally
do we
separate.
find the last court order?
My lord, last court order, I
Or
have
annex?
the charge sheet is there, my lord, but I could not able to annex the last court order, my lord.
Now, where do we find the number then? The
GR number, my lord.
GR number is there.
GR number is there, my lord.
Last order you have not annexed.
Not annexed, my lord.
Why you didn't care to file at least the last order so that. And then you see after filing of charge sheet, after court examination, you said that court has already examined
Yes,
and you are still in the police statement.
I have only, my lord, I have only.
What
annexed
is
the charge sheet.
what is, okay, this is domestic violence.
Yes, my lord, 498 IPC only.
Mhm.
So since we have, my lord, resolved the matter and then now we are legally separated.
Let us just forward. Okay, you are, when you were married,
Since 1993, we got married.
where do we find that?
That is in my lord FIR mentioned by my wife also. That is matter of fact, my lord. We got
Okay,
married in
then,
1993.
there is children born out of
Out of wedlock, we have 2 children.
that statement in your
That
petition.
is not completely written in my petitions.
Hmm?
Para number 3, my lord, in my petitions. So about the children, now one son is no more alive, my lord, due to some reason he was died, and our daughter is there. So I'm looking after the maintenance of the daughter and providing maintenance to my daughter.
She is has become major now.
Yes, yes, he is major now.
92.
Even though, my lord, I am providing maintenance to my daughter.
Where is the agreement?
My lord, it is in page number 43, my lord, annexure 3, my lord. Mutual divorce agreement we have done, my lord, and then there is some conditions. My wife has also agreed that she don't want to pursue the matter in
Where do
this
we
present
find
case.
that statement?
Yes, my lord, that is in page number. My lord, that is in page number
46.
my lord. Para number 4, my lord. Page number 47, my lord.
Okay, what is the
Second party shall
settlement?
not claim for any
Let us
alien
see the
matter.
condition of the
Yes, madam.
settlement. Okay,
Execution agreement shall
So-
withdraw the present pending case WBS case number 90/16 year number so and
Okay.
so, madam.
so there is a,
Mutual settlement.
okay. Some property also given.
Yes, madam. Whatsoever property I have already given to her, my lord, the immobile properties. That is also mentioned in mutual divorce settlement.
Okay. Yes, yes, Mr. Yes, comment.
Since they have arrived into mutual settlement and they are already
So,
Di-
yes, yes,
di-
here
divorce.
today you have annexed decree of divorce also.
Yes.
Where is the
Annexure
operative-
number
where is the operative-
4 and 4, page number 49, my lord. This is decree of divorce.
operative portion?
My lord, operative portion is page number
Okay, 52.
52, my lord.
Hmm.
Order has already passed by Honorable Session Court, Session Judge, District Judge.
Whether the husband is now married?
No, no, yes, yes, my lord. He has also got married with some other men.
And the wife?
Wife, my lord, so far she has not married with some other men, but
Okay. So the petition can be allowed.
my lord, there is Honorable Apex Court has so many judgment as per under section 498 if parties.
Have you
arrive
stated
at
that
settlement.
any judgment? Have you?
I own judgment, my lord, but if Honorable Court may permit, my lord, I may submit judgment based
You
on
submit one judgment, then
BS Joshi and
okay. Will dictate. You submit one judgment,
my lord.
that so that we say that you have relied on this
Yes.
judgment. Okay.
Yes,
Okay. Hard, Mr. N. Rama, Land Council for the petitioner. I have also heard Mr. G. Taro, Land additional P2. Okay. This will be disposed of. Name, address. This application under section 528 of BNSS 2023 has been filed jointly by the which one is the accused?
my lord, petitioner number 1 is accused, 2 is a complainant informant.
Joined by the petitioner accused petitioner number 1 and informant petitioner number 2 in where is the in the GR case number 685
Yes,
stroke
my lord.
2016
Yes.
arising out of the Itanagar Women PS case number 90 stroke 2016 under section 498A of IPC. For quashing of okay. The prayer of the petitioner is to quash and set aside the above GR case number 685/2016 arising out of so and so on the ground that there has been on the ground that the case has mutually been settled between the parties by executing a this is mutual divorce, okay?
Yes, my lord. Mutual.
By executing a mutual divorce agreement dated 9/2/2025. Okay, rest alpha.
Yes,
Hola.
much of it.
Item number 7,
My lord, this one is also causing of FIR, my lord.
Okay.
My lord,
7
causing
is also.
Yes, also. They have jointly filing the petition for causing of
This is
FIR.
also joint petition.
Yes, my lord.
Who are they?
Here in the petitioner number 1 is the accused, my lord. 2
One is
a-
accused.
2 is a complainant, 3 is a victim in the case, my lord.
2 is
2 is victim,
Informant.
2 is informant, 3 is victim, my lord.
Victim, what is
Yes,
the,
one is accused.
what is the allegation?
Allegation is, my lord, physical assault under petition
Page
number
15.
2 by petition number 1.
Let us see.
Section 324 IPC is there, my lord, case was registered. This is
41,
case of 2009, my lord.
wrongful confinement. So, and this was laws when?
2009,
Case
my
of
lord.
2009.
12 to 2009, my lord.
Okay, just, there is just. Are they related or?
My lord, they are residing in the same locality, and as a neighbors, they have settled since matter is also old, and now there was no any such intention from the part of accused to harm the victim. There was some relation of love and
Okay,
May I just-
Case is of 2009.
yes, my lord.
What is the status of the case?
Status of the cases, my lord,
Charge sheet submitted.
charge sheet
Charge
submitted.
sheet also submitted,
Yes.
also submitted under the same section,
Yes, my lord.
same offense.
My lord, charge sheet submitted
How-
under, yes, my lord, just.
How many accused? Only one accused.
Only one accused.
Okay.
Charge sheet submitted under section, initially, section 452, 341, 424 IPC.
Where do we find that?
That is in FIR, my lord, page number 14. Your lordship may find page number 14 in FIR.
No, that is FIR. Where is the charge sheet?
Charge sheet, my lord, my lord may come to,
Is it
my lord may come to page number 24, type out copy, my lord. My lord may come to page number 24, which is prosecution history, type copy.
Okay, 452.
452,
341,
341, and 324 IP.
And what happened there in the court?
So, my lord, during the time of framing of
Charge
charge,
frame.
section 448, 324, charge has.
Where do
framed
we
against
find
the-
that?
Sorry, my
Where
lord.
do we find that?
My lord, that other I'm extremely sorry, I could not able to annex in the petition, my lord.
See, the basic document which you are based on and based on and then pray on the basis of that document, you should always annex.
Yes.
How do you expect the court to? Then in that case, you see, we'll have to call.
Lordship, difficulty is lordship in this matter is in which court this matter was pending, lordship. Even he didn't mention lordship.
Then it will be
Only
difficult.
only GR case was mentioned, lordship.
We'll fix it after 8 weeks.
My lord, I have clearly mentioned in my para number 7, my lord, in my petitions, that is pending before the Learned Court of Chief Judicial Magistrate at the UPI, my lord. I have mentioned in my para number, petition, para number 7, my lord.
But not in the prayer.
See, in the prayer, you have to make, you have to clarify that which GR case pending before which court is to be set aside and quashed. Unless there is a prayer, we cannot grant more than what is prayed for.
Matter is pending before, my lord, Learned Court of CJM in UPI, my lord. I mentioned in my para number 7 of my application. Here also, my lord, the party has
Don't
usually-
be in hurry while filing any petition. Include everything.
Yes. They have also entered into agreement, my lord, mutual settlement agreement, my lord.
Now you see in the prayer, you have not mentioned the GR case. Okay, GR case
I
is
have
there,
mentioned, my lord.
not pending before any court. No, you have not mentioned.
Name of court, my lord, in my prayer, name of.
See,
court
and
is
then,
not
no,
mentioned.
I think we need to call, because the charge frame under which section you said?
448 and 324 IPC. 324 is the.
Then
comfortable in-
we'll call for the record first. Let us ensure. You are not sure about,
Lordship, in the
that is why you have not given any statement.
Lordship, in page number 24, Lordship, the accused is under 452, 341,
324 IPC, Lordship.
That is why
Yes, Lordship.
the record till now is these three sections, and then we do not know. So if any, even if the
My
other
lord,
pass also,
in that case, my lord, I may allow
in
to
wrong
put
order,
additional
supposing if this two IPC section is set aside and one remains, then what
Yes,
next?
yes, my lord, that is, so in that case, my lord, I may
Okay,
allow
hard,
to
Mr.
file additional affidavit, and my lord, until then, proceeding may be
Mr.
stayed, my
Endra,
lord.
Planning Council for the petitioner. I've also heard Mr. Loilana PD for the state. By filing this application under section 528 of BNSS 2023, the petitioner prayed for quashing of the, you said, now this has come to the court, and then you are still praying, okay, of the GR case, where is it? GR number 5656/2011, arising out of
Palijan PS.
the Balijan PS case number 2/2009, under section 448324 IPC. Issue notice. And a call for the scanned copy of the trial court record. Issue. Okay. Who is the victim? Is three.
Victim is three.
Two is informant.
Two is the informant, my lord. Petition number 2 is the informant.
List this matter again on when? This is UPIA.
Yes, my lord.
Then on 11 or 10.
Or Lordship, since TCR was called for Lordship,
Scan copy or
yes,
scan copy. Then when?
okay, 11.
11. Okay.
11.
Okay. 12. 12.
Yeah, 12, my lord.
We'll say 12. Okay.
In the meantime, my lord, I may allow to furnish CTC copy of the charge which.
Okay.
Lordship may.
Okay. Mr. Rama, Lani Council for the applicant pray for allowing him to file additional affidavit.
Yes. Framing of charge order copy from the
Okay,
Lorna
by affidavit by incorporating the court, the order passed by the trial court. Okay.
Yes.
Since trial court record, we are calling for, but then of course you have not made prayer.
Yes.
Prayer also, that is okay.
Date of CC, I have mentioned, my lord, but I could not able to annex the order which passed by the Lorna court.
For amendment of the prayer as well as for incorporating some the order passed by the trial court in the matter. So the prayer is allowed. Okay, my lord.
Deeply right.
Then we'll continue at 2.
My lord.
May I, Your Lordship?
Yes, please.
Your Lordship, I beg to mention item number 19, Your Lordship.
19.
Yes, Your Lordship. I apologize for not mentioning in the morning hours, Your Lordship.
Okay. So what do you want?
May it be fixed on 15th of this month, Your Lordship.
Yes, you're for the petition.
Yes,
Okay.
15th of this month. This is a 2021 matter, Your Lordship.
On the prayer made by both the Lani Council for the appellant as well as by the respondent, let this matter be fixed on, listed on
15th of this month.
15 September.
Yes.
Okay, 15.
Deeply obliged.
Item number 8, May I please? My lord, I beg to mention item number 8.
This is criminal petition only.
Yes,
What do you want?
my lord, matter may be taken up after 3 weeks.
After 3 weeks?
Yes,
You
I have
for the
already
petitioner.
informed to. I am for petitioner.
Okay, so this is quashing petition
Yes,
on merit. You have not yet filed affidavit in reply.
actually, my lord, I am not well acquainted with the fact.
Okay, but
so
you, who is there then? Who is in the case? Deloitte,
G Kato.
G Kato. So affidavit in reply, you were to file affidavit in reply, not yet. Probably you have made a prayer earlier to file affidavit in reply. Okay, we'll grant you some more time.
Yes, on next date we will file.
Mr.
Mr.
Your name is there,
No, I am appearing on behalf of G Kato.
appearing on behalf of Mr. G Kato, Land Council for the petitioner, prays for further 2 weeks' time,
3 weeks, my lord.
3 weeks' time to file affidavit in reply to the affidavit filed by the Land Council for the filed by the respondent. So the prayer list is matter. After 3 weeks, Mr. G Kato, Land additional PP appear on behalf of the state. Okay.
Highly
Mobilize.
Item number 10.
Mr. Dero, this is ready for hearing. It appears it was already admitted.
It was admitted, yes.
The ready for hearing.
It's ready for hearing. Pleading has been completed.
Yes.
They have filed their opposition affidavit also.
Okay. So, third, Mr. S.K. Deori, Land Council for the petitioner, who submits that the matter, who submits that the pleadings are complete and the matter is ready for hearing. Stop. In view of the above, let this matter be listed for hearing after.
My lord, any.
Your correspondent.
Yes.
You have filed your affidavit,
Yes, my lord.
so we'll fix it for hearing.
My lord, it did not be taken up today. Mr. Tako is here for hearing.
No, that is why this is ready.
Yes.
It will be listed for hearing now. Because the matter has already been admitted. So now, since you have already filed your affidavit, the matter is ready for hearing.
Yes, my lord.
So we'll fix for hearing next stage. Okay, it was listed for admission.
Yes, sir.
It is already admitted. Now it will be listed for hearing.
Yes.
Okay, when?
My lord, I may be allowed to take instruction.
Not required. It will be listed for hearing only.
Date, my lord.
You want date?
Yes, a fixed date.
Okay, when? Okay, then Mr. S.K. Devananda. Also had Miss, you are Miss
M. Karva?
M. Karva. Your name is there?
Yes, my lord.
It is not appearing in the cause list. Oh, okay, M. Karva. Okay,
M.
sorry. M. Karva. Land Council appearing on behalf of the respondent. Staff indicated that the pleadings are complete and the matter is ready for hearing. Staff, in view of the above, in view of the above, let this matter be listed. For hearing, you want date?
Just my brother.
Okay.
Then, my lord. 21 of October.
In view of the above, and as requested by the Land Council for the parties, let this matter be listed on
22nd of October.
22.
Otherwise, Lordship, the matter is very, it could be disposed of
Let it
also.
be listed on here for hearing of the, if you want early, that we can fix early then.
No, it's all right, 22nd October.
22nd October, okay, for hearing, okay.
Apply.
Item number 11.
This is item 10.
May it please your Lordship.
Yeah.
My lord, I would like to draw your Lordship attention on earlier order dated 2/7/25, my lord.
Okay, what is that? 27,
25.
yes,
Here, your Lordship, on the last paragraph, your Lordship, it was
Hmm.
written, the list this matter after the ensuing summer vacation. Only
Oh.
date to be fixed by so and so. If the learned counsel petitioner does not appear, this court may proceed to dismiss the petition for default.
So this will be listed, that means it was to be listed after the.
Your
summer
Lordship, it was
vacation.
listed after the vacation.
that
So
is-
now, Your Lordship, if today they fail to appear, then Your Lordship
Oh,
please to
earlier
dismiss.
non appears.
Yes, Your Lordship, in many
This is what
occasions.
this is quashing petition.
Yes, for criminal petition, my lord, it can be dismissed on default, Your Lordship. It is not a revision and neither an appeal, Your
Yes,
Lordship.
yes. Consensus or on merit?
Your Lordship, it is on merit.
On merit,
Yes, my
then
lord.
I think it can be. Okay. None appears on behalf of the petitioner on call. No, none appears for the petitioner on call. Start. Whereas Mr. T. Telane, additional TP, he is present for the state staff. The record reveals that on the earlier occasion also, the petitioner remained absent. On 2/7/2025, this court made an observation. This court directed the matter to be listed after summer vacation. And observed that on a date to be fixed by, and after summer vacation, on a date to be fixed by registry. It has, and made an observation that if the learned counsel for the petitioner does not appear on the next date, this court will proceed to dismiss the petition for default. Stop in view of the above and above. It appears that the petitioner is no longer interested to pursue with the matter. Accordingly, this criminal petition is dismissed for.
Yes, oblige. Your Lord.
Matter number 12.
Yes.
Lordship, we are trying for the disposal of this petition, CRP. The contention of the petition, I am for the respondent, Lordship.
You have responded.
Yes, sir.
Yes, sir.
And the contention of the appellant, the petitioners, is that there was a appeal, Kavang appeal. But on the hearing of the appeal, the decision was not passed on that day due to time decision. There was a 14 judge members on the appeal hearing that. Out of 14, Lordship, 7 judge was
That is
in.
bad idea. It should be always odd number.
Exactly, Lordship. That's why on that day, Lordship, they fixed some other date by adding another 3 Kavang members. And decision was passed after 3 days, but date of decision was mentioned as the original hearing date, 29.
No. On which date these 3 persons were not present.
Yes, exactly, Lordship. So therefore, Lordship, may I humbly pray that the judgment passed by the Kavang affiliate authority that set aside and
Send it back.
yes, send it
Separate.
back for fresh hearing of my appeal because my appeal was statutory appeal. So fresh hearing to be done on my appeal and pass the appropriate decision.
What do you say?
My lord, number one, their complaint has been taken into cognizance and Kava was conducted, which my learned friend is conceding that Kava was not properly conducted and is conceding for setting aside. If it's set aside, then they may approach the further forum, not to conduct recover. They may approach appropriate forum like civil courts and all. There are provision that is judicial impropriety say that they can approach. But recover, that we object because when it's set aside, into
If
account.
the Keba decided after appointment of this 3 more Keba member, after 3 days of the original.
Let's see what happened in that second Kava. One Sri Morli Ori. In earlier Kava, he was in my favor. But in the next Kava, he changed his statement and he stated in favor of the respondent. There are lots of intermediaries in the Kaba.
Then the Kaba has to go.
Yes. Moreover, Your
Has
Honor,
to go.
moreover, my lord, out of the umpire, 14 umpire, one was the umpire and other was the Kaba members. There were 7 members in favor of Mimi, 6 members in favor of them. The umpire should have recognized the majority. In spite of doing that, he goes in favor of the respondent, not recognizing the majority decision. Those lots of discrepancies are there. Therefore, we are here. Moreover, till that, the act has constituted these inter-village territorial court, but it has not been notified yet, not appointed. They are just functioning illegally because it has to be constituted by the deputy commissioner as per section 5, but not yet constituted. They are functioning.
No, constitution.
It's a decision passed by the quorum non-judice.
No. The Kaba need to be constituted by the deputy commissioner.
No Kaba, appointed by the deputy commissioner to the head Gamburas.
Hmm.
Gamburas are appointed by the deputy commissioner. Yes. Territorial court, as per deputy commissioner should constitute the inter-village this territorial court, which will determine which villages will come in that inter-village.
In which provision it says?
No, since Gamburas are appointed under section 5 of AFR,
Yes.
then no
They
further
are automatic.
separate members has need not be required to appoint.
Yes.
Appointed, but this should constitute that these villages will come under this territorial customary court and this should appoint one chairman. It is not happening there. They are just functioning based on their circle, CO circle areas, administrative areas.
What is the practice and practice for this territorial jurisdiction? Who has the
Lordship.
power and authority?
Lordship. What my brother submitting, Lordship, as your Lordship aware that the Gaburas are appointed by Deputy Commissioner.
Yeah.
In terms of Civil Act, Lordship, it's provided the appeal from the Blaze Authority, it should be inter-Blaze Territorial Customary Court or Apex Court. Now, the practice, Lordship, is what happened. Once the Blaze Authority passed the decision, then appeal should be filed before one of the head GAM within that territorial blazes. Accordingly, they constitute Kawang members. And Section 17 of the Civil Court Act 17(2) says that, Lordship, the Kawang members who passed the original decision, they should not sit in the affiliate form.
Yeah.
That is the only restriction.
Mhm.
And in my case, Lordship, of course, after Kawang order passed by the Blaze authorities, I have filed a appeal before the affiliate authority. There is no any wrong in filing appeal. Appeal was filed in right forum. But the problem, what I consider is, Lordship, that on first 29th date, Kawang should have passed their own decision. But because of the tie decision, because they have appointed 14 members, wrongly, because they are not that aware. But however, 14 Kawang members was there, out of which 7 was in favor of the petitioner and 7 was in my favor. Only what happened on that day, they didn't pass the Kawang decision, but they postponed it to some other days by appointing another 3 Kawang members. And on rehearing that, the petitioner did not appear, saying that there cannot be re-for one. Accordingly, that hearing was done ex parte and decision was passed, which the petitioner are challenging here.
Okay, that means the
May I?
Re-Kaba was ex parte.
Ex parte. Because when re-for-one was
And if
issued
it
by
was-
adding a 3 Kawang members, the petitioner submitted a representation saying that there is no provision for re-Kaba.
Otherwise, there is no dispute with regards to the jurisdiction.
Yes.
The jurisdiction I am disputing because
You're disputing
government has not
jurisdiction.
constituted the territorial court
No,
based on that.
where it says that it has to be constituted by the deputy commissioner.
No, deputy
jurisdiction.
commissioner means because since they are appointed by deputy commissioner, so deputy commissioner has the power to constitute
Now,
under section 5
Hmm.
of AFR. Since he appointed the head Gamburas and all,
yeah,
power has been given. So he should constitute the inter-village territorial court.
No,
There is no
no.
constitution.
that is what
no,
I am
Or else
asking.
the government will
That is
constitute.
what I am asking. Where it says that the deputy commissioner has to constitute.
No, Lordship,
There is no
absolutely nothing, Lordship. But
nothing.
the Civil Court Act,
Then-
Lordship, amended Act 2022, it simply
Have
provided.
you annexed the civil code act? No, do we have the copy?
Annex.
2020. It's provided amended Act 2022. It simply provides that, Lordship, An appeal from the Blaze Authority, if agreed to by the parties, shall lie before the Inter-Blaze Territorial Customary Court or Apex Court by whatever name.
Which one you are reading?
2022 amendment.
22 amendment.
Yes, Lordship.
Okay, so and section?
Section 3.
Yes.
In original act under section 15, the provisions for appeal has been provided, Lordship.
Yes.
But and accordingly by this amendment, the under subsection 3 of 15, that clause 3 has been inserted, Lordship. Next page, page number 2, Roman 3, Lordship. After the fourth proviso to subsection 3 of section 15, the following subsections shall be inserted. 4. An appeal from the Blaze Authority, if agreed by the parties, shall lie before the Inter-Blaze Territorial Customary Court or Apex Customary Court. Now, this is the only language, Lordship, where I have to file. The aggrieved party who aggrieved the decision of Blaze Authority, they have to file. But what my brother is raising regarding the appointment of this Territorial Customary Court, there is any provision as such has been provided.
So where is the
Accordingly,
rule regarding this rule?
yes. Lordship.
Is there a rule?
No rules.
No, nothing, Lordship.
Rule not yet.
Not yet. Therefore, now the practice is, Lordship, once the particular Blaze Authority, 8GB has passed the cover decision, then the appeal has been filed before one of the head gum of that in territorial Blaze jurisdiction.
Unless the rule says that it has to be constituted by the deputy commissioner.
Yes, Lordship.
And I think
But the problem is, Lordship,
the-
though it is provided the territorial
Let it be
customary court,
interpreted,
though it is provided that the territorial customary court or apex court by whatever name, but how we will know that these are the territorial court?
No, this
Earlier, my lord,
this was constituted based on what? Circle or what?
earlier,
Circle,
my lord,
entire territory within circle, Uguwango circle.
earlier, my
What is the
lord,
understanding when the village authority constitutes the what is this? Constitute apex court, apex customary court,
Yes.
or inter-village territorial customary court. What do we understand generally? Is
Yes.
there anywhere explained that it covers the circle
No loss.
or is the journal or what?
no, earlier, my lord, earlier, my lord, what happened? There was Bango level system earlier,
Bango
which has been
covers-
set
the
aside.
The Bango level is
Earlier, that
circle or-
practice is followed. That Bango is now acting like a territorial court, inter-village territorial court.
so that Bango covers how many? It's a circle.
Basically, the SEO
Bango is
circle.
basically circle.
Some SEO circle, some more than SEO circle, based on the area.
How do we know? From where do we gather this information? How do we know that this is in somewhere it is a circle or it is somewhere more than circle?
My lord, suppose in this particular case, there is a Kodum circle. Those villages within that administrative circle, they constitute that inter-village territorial court, or that's a Kodum Bango. And there is a other Bango,
Is
Bango.
there any written documents
No, it's a practice.
where it is only practice?
Yes.
Practice.
Somewhere you do, can we find somewhere mentioning that this circle means covering this?
Nothing.
No loss.
No,
No. In
Then it is only-
AFR also,
In case-
and then civil court act, nothing.
case wise it is mentioned by the Kebang.
By issuing Parwana.
And only from the appointment of the Kebang member, we could understand that, yes, this covers this
Yes,
area.
this place, yes. Yes.
So this 14, 7 plus 7, 14 covers how many villages
This is, yes, it is.
in the present case?
Yes, that Ogubango area, it covers almost 5 or 6 villages.
Okay, so that is circle.
That is circle, within that circle also.
Okay, so it confine, the
It confine-
authority here in the present case covers the circle.
Yes, Lord.
Okay, that is where, and then this is called Bango,
Interplace.
inter-village. So that way probably the jurisdiction, territorial jurisdiction is settled by appointment of the Kebang member,
Yes.
that these are the village which covers
Exactly.
this territory, this
Yes, Your Honor.
inter-village territorial customary court. Okay. So then with regards to the decision, there was, the first decision was done in 29.
Oh, hearing was done on 29, Lord.
Hearing done on 29 by 14 members.
Yes, by 14
Okay.
government.
So where do we find that?
Cover decision.
Our decision, Lordship, because actually, Lord, in fact, it can, we can claim it through the Farwana only. Because on 29, no decision was passed, Lordship.
No, where have you stated then in the body of the
Cover
appeal-
decision is-
appeal memo?
Your Honor, at Annex 8, page number 33. 19.4.
This is in what?
Impugn cover decision is
Okay, this is admission. Okay.
49 phase. Annex 13, 49 to 50.
Has it been admitted already?
Not yet admitted.
What we will do, we'll admit it and then fix it next week, Tuesday. We'll pass order on Tuesday. Or you want dispose of today itself?
Subject
My
to
lord,
Lordship.
my lord,
Because
one
I
thing we are agreeing that
because
this should be set aside that my senior
Then-
friend is conceding.
then we
The
can.
only on that
Huh.
recover, we shouldn't want recover because when
Then if it is set aside, then what next then?
Yes.
they will
automatically-
approach the appropriate forum.
No, no, what will be
No.
my appeal?
No, Your Honor, my lord, there is a provision either after the appeal from village authority, inter-village authority,
No,
they can
see,
approach
see.
the civil
Here,
court.
here
No,
the
no.
decision has already been done,
No,
it
no,
appears.
no.
Decision has already been done. Along with the addition of 3 more Gamboras.
Not only that, Your
11.
my lord, not only that. On the earlier meeting, second meeting,
Hmm.
those persons who have stated in my favor, in next meeting, in my absence, they stated in favor of the
No,
respondent.
that will not be
He cannot
counted now.
compel the.
More so-
will not be counted now.
More so, my lord, more so, those village authorities against whom the decision has been appealed, those persons also in the, which is not permissible,
That is-
permissible,
That
in,
is,
especially in appeal.
When you agree that it should be set aside, see, the earlier decision, if it is to be set aside, then the earlier decision on 29,
yes.
on 29, that is, you see, the 29 is not before us.
So-
The decision, 29,
29
earlier
is,
decision, according to you, on
29 is here.
29, 7 in favor, 7 against,
Yes.
isn't it?
no, Your Honor, one was umpire. Actually, 13 government members were
No,
there.
the
One was umpire. Umpire cannot be considered,
umpire also decided in favor of.
Yes.
umpire should recognize the majority, but
No,
he,
no, where is the?
How it is possible? How it is possible? It is not possible. Umpire, only because of the majority, if he agree with this decision, he will go here. But in the case where there is an odd number, then of course, umpire will go where he want. Okay? What
My
is
lord,
his decision?
that
Or
is,
our majority.
that
what
is
the-
also our ground, my lord.
But then
There cannot be even cover members.
even cannot. work.
That itself is illegal.
That is the wrong forum actually, constitution of the forum. So that 29 decision goes. On 29, even 5 member against or 7 member, or sorry, 9 member for favor, whatever may be, but then that automatically goes. In the final decision after addition of the 3 more Gambura in the forum, then that would be the final decision. That would be the final decision. Earlier, because that is rejected only because of lack of forum, lack of quorum in the forum. Okay, so now after 11 members, 14 plus 3 is a 17. In the 17 members, now they have, because here the decision may change, the member may change their decision also. Vote for this, okay?
Yes.
That can happen. So that way, this decision will remain. If you want, if the party says that this decision, let this decision be decided, or because decision, if that will remain, but then let the decision be on the date when the KEBA decided, finally, after 29. They can sign it again also by changing the date, because if their decision is still the same,
Yes, Lord.
they can do that. But with that we cannot say now, because since we are setting aside, let them redecide. If they decide that we will stand by the earlier decision, but the date also only will be changed.
Well,
because
what I'm praying
of
is,
the 3 more members.
by setting
who have
aside
decided
this,
finally on.
just liberty may be given to the party to approach appropriate forum. That covers, I think,
No, Lord. Then what?
When we send back,
Yes.
it has to be there.
Hmm.
When we send back, because it is not a question of on merit, on merit of the case. But the merit has already been decided by the KEBA member. Now we are only because of the defect in the date, signing of the date.
Not
We are
only that,
sending-
there is lots of discrepancies, my lord.
What discrepancy?
It has to be then started from the beginning. Matlab, those Gamburas, they are not evidence. They are the Kaba members, the umpire, the decision maker. One, they decided in favor of me. Next
Now-
meeting, they
now
decided in
if-
favor of
Now,
the respondent.
the
How can a
evidence-
judge change his view in subsequent
this
to
was
today?
decided. This was decided after recording the evidence, isn't it?
Yes.
Now we can, of course, restrict that no more evidence, but based on the evidence already recorded on that day, the KEBA member will decide.
And my lord, to take a pass ex parte decision, at least 3 consecutive parwana has to be submitted. I mean, issued. Only in the next parwana, they just pass ex parte order, in spite of submitting an application requesting them to postpone the
Each and
meeting.
Every time 3 parvana.
Yes, that's there, Your Honor.
Yes.
It's provided.
Each and every time.
Yes,
Yes.
Lordship.
Even
By,
if it-
by giving 30 days time.
30 days time.
That is for the fresh cover, Lordship. But this is not a fresh cover, Lordship, because on 29.
That is what I'm saying.
Yes.
That is what I'm saying. I'm asking for each KEBA.
Yes,
Because in initial, I know that 3 parvana
yes,
gave of 30 days.
30 days.
Okay.
Yes.
In between each
Yes.
KEBA. So that the opportunity should be given to
Yes.
the opposite party.
Yes. Yeah.
But here, since the case was already decided and fixed,
Yes.
was next day, immediately after 3 days.
Yes.
Oh, how many days?
that they not decided. It was split decision.
On the agreement
And-
of the split decision.
Yes, earlier 29 decision was 7-7.
That is why they have redecided to constitute
By adding
or
3
to
new.
fulfill the quorum
Yes,
by constituting an odd number of members.
So that is, in 3 days, they constitute at least enough time may be given to
You were also present there.
No, I was not
he has
present.
submitted a application saying that I am not going to attend in the recover. Decision should be passed in terms of 29 hearing.
So that hearing, because the 29 hearing was done after recording of evidence only.
Yes,
Now the evidence stays closed.
Your Honor, my lord, just see on 29 statement, everyone's statement taken. Again, next day that fixed. Then only hearing of the new included have been recorded. But again, they after 3 days recorded all the statement. Then again they changed, some of them who was in favor of me, they changed their statement. Such kind of conduct, how this court will permit? More so, even in express cover or appeal, when the authorities are decided to pass an ex parte decision, at least that opportunity of 3 times
So
parwana should be given.
What is your prayer then? Because you are a petitioner
Yes.
and you want that the impugn order should go. It will
Yes.
go, but then
Yes.
then again, with the prayer that, let us see your prayer. Pass and set aside.
It's page number 15. Decision dated so and so.
See, you yourself has said that decision dated so and so as non-est. Impugn keba, declared impugn keba decision dated so and so as non-est. Yours are more, the prayers are more than what you are submitting now.
Yes.
There is no proposal from the side. And then there is no prayer, what you are submitting.
From page 11, my grounds.
So what are the discrepancies other than this?
Number 1, those Gamburas against the decision appeal, they are also they have also been in the as a Kaba member in second Kaba.
judicial propriety doesn't allow that. How can Ekaba Gaumbura, against whose decision I'm appealing, they will sit in my appeal proceeding? Since there is no constitution of interpretorial court, the members are pick and choose by the
What is your, this Ububang?
Ububango is the Kodum circle, CO circle area.
Circle. That circle is called as Ugubang also.
Ububango is circle.
Yes,
CO circle.
within circle. That circle.
Now, then if you are disputing, I have to see it again. So we'll fix on Monday. Okay, since you are disputing.
Otherwise, Lordship, what my
Yes,
brother submitting.
because if it is for saying, for remanding back for the decision with the proper quorum of the constituted
Constitution of Intervallate Territory.
territory.
There is no such provision
So
or
then in
any
that case,
guidelines.
same disposal, but then he is disputing. So in that case, we'll have hearing, a little bit of hearing on Monday. We'll dispose of on Monday. Let me also go through the provision
Laws.
if there is any. Because this is admission. What we'll do, we'll admit it and then fix it for hearing on Monday. We'll dispose of. Okay.
Let it be remain on admission hearing, Lordship.
Admission hearing?
Yeah.
Okay. Then in that case, Mr.
Emmet.
Mr. Soran,
Emmet.
sorry, Emmet Mepete, Land Council for the petition. Also had Mr. K. Lolo, Land Council for. Or is the sole respondent or how many respondents?
Two respondents.
Two respondents.
I'm
Representing
both
both
respondents.
for the respondents. On the prayer of both the Land Council for the power. Let it be listed again. And then in that case, Monday or what?
Monday.
Okay, Monday. Okay.
Weekly oblige.
Item number 13.
So on that day, if there is any decision and if there is any information or decision regarding the territorial, because you are disputing, so kindly bring.
Yes, Lord. Lord.
Okay. Starting, okay. Yes.
Oh, may I, Your Lordship? Your Lordship, in this case, service is still awaited, Your Lordship.
Sole respondent.
Yes, Your Lordship.
Okay. Mr. J. Land Council for the petitioner is present. The service upon, notice upon, where is service? Respondent, sole respondent.
Sole respondent.
Upon a service upon the sole respondent is still. You want to take fresh steps or just wait?
We'll take fresh step.
Okay. Then in that case, in view of the office not dated 3/9/2025, Mr. J. Sirin, Land Council for the petitioner, praised for allowing him to take fresh steps upon the sole respondent. Staff prayer allowed. Steps by a registered post with AD as well as by usual process. Within a
One sentence may be added that since the address is given in of Alo,
okay.
so we'll determine whether the staying
Okay,
in Alo or whether it's in Itanagar.
Okay,
Because the
take steps,
disputed land is
upon the sole respondent after ascertaining the proper and current address of the respondent. The prayer is allowed. Okay, then steps upon the respondent. Yes, sole respondent. Within then, how long it will take to ascertain the address?
within a week.
Okay. The steps within by register post with AD as well as by usual process within a week. This matter after 3 weeks.
3 weeks.
Okay.
Item number 14.
Yes.
My lord, I'm on behalf of private respondent number 2 here in case.
Yes. Yes, who is for the petitioner?
Your Lordship, I'm for the petitioner.
Yes.
Service report is still awaited.
No, no, my lord, we are appearing since 25/6.
You're for?
My lord, I am on behalf of 2, my lord.
How many respondents are there?
Only 2, state and private respondent.
Okay, you have filed wakalatnama.
Yes, my lord.
Yes, it is.
We also appeared on the last occasion, my lord.
Okay.
26,
Sir.
25 matter was the state, so we were appeared, but petitioner was absent on that.
Whether any record was called for? Record probably was not called for. Record would be necessary.
Lordship, yes, Lordship. But Lordship, they have challenged the order, Lordship, impugn
Okay.
order. So it is
It's a
order
revision
already
petition,
annexed.
And
Lordship.
then record necessary.
Yes, Lordship.
Okay. Mr.
Pironia.
Planning Council for the petitioner. Also had Mr. N. Rama, Planning Council appearing on behalf of the respondent, sorry.
Private respondent number 2, my lord.
Planet additional PP for the state and Mr. N. Rama for appearing on behalf of the respondent number 2. It appears that trial court, it appears that in the instant case, the trial court record would be
My
necessary.
lord, this is the order being petitioner challenging the order of the ADC Valijan, my lord. ADC Valijan,
Okay.
executive.
So what order was there?
My lord, this order is only to restrain him for impose the land of the private respondent. Under
Okay.
section 188 has imposed against the private petitioner.
Mhm.
So now the case seems to be not maintainable in the form of, my lord, criminal revision petition. Rather, it has to be filed under section as per provision of, or maybe he has to approach before the civil court.
The order was passed by ADC.
ADC Valijan.
Marijan, what order was this?
My lord, order is, it is.
Can you just see once?
Yes, my lord, order is page number 6, page number 3 of their petition, my lord. Annexure 6.
50?
Yes, my lord, 50. Lordship, my lord, may permit read out the operative portion.
Just a minute, just a minute. 50.
Yes, my lord, 50. In their petition.
What petition they have filed?
My lord, the fact of the case is that I have a plot of land, which we, Gaumburas and the Gaumburas villager has decided in my favor. And we have a clan, Chera clan family members. I'm representing on behalf of Chera clan. And now this person is from Rus village. The place name called Rusi. So that place is still under Sandupota circle, under Palijan sub-division now.
Okay.
So thereafter, what happened after complete decision was taken and we established there in the place where I have been allotted to occupy the portion of land. So this person petitioner is trying to encroach my portion of land, madam. So thereafter, I launched complaint before the ADC Valijan, madam, as well as FIR, madam. So after launching of FIR, because
This order was passed in your complaint, a complaint lodged by you.
yes, my lord, complaint launched by me and the ADC has.
What about the FIR?
FIR case was
Registered?
Yes, madam, not registered. So I hope the case concerned OCPS Balijan has investigated the matter, inquired the matter, and that inquiry report is submitted before ADC Valijan, my lord. So that is they have also enclosed in page number, my lord.
Okay, let us see the impugn order.
Yes, my lord. If Lordship may read out, Lordship may continue.
Yes, please.
Lordship also read out the third para of the page number 50.
Just a minute then, just a minute.
Yes, ma'am.
The complaint. There was a status quo order also.
Yes, my lord, status quo order was passed against the petitioner, but
Where is the status quo order? Where is the status quo order?
my lord, that status quo order I have. Lordship may find
No, since,
page
okay,
number,
then what we'll do
page number
is
41.
since you are appearing, and then we'll fix it for admission.
Yes, my lord.
Okay.
Yes. Page number 41 is status quo order passed by ADC Valijan. So, in
Page
against the
40?
petitioner, ma'am.
41.
Yes, my lord, page number 41. to restrain him to encroach for the land of the private residence. So even then he has continuously encroaching, then thereafter I was launched FIR, and based on FIR, I of the OCPS has input the matter and report has been submitted to ADC Balijan. And thereafter ADC Balijan again called the Gavras and all
Pending in this.
thereafter examine and cross-examine, then he has passed his impugn order, madam. What they are now challenging before. the
Yes,
court.
yes, sir. Here is a step. Means. We didn't dispute it. Status quo order is there. So basically the case was pending before whom?
My lord, there is no case pending
Before the
for any other.
no, not before the Keba.
Yes, madam. Suppose petitioner has to, if he has not agreed with the decision of the village authority, madam, he has to challenge, appeal before the civil court, madam. Civil judge, senior division or.
This is under, this order was passed under what provision of law?
It seems to be,
It
ADC has
seems
passed
to be
under section
CRPC,
45 of
but one
some Frontier Regulation Act.
45.
Yes, 45 ADC. has
No, what
passed.
is the complaint? Where is the complaint for leading to passing of this order?
My lord,
Where is the complaint?
yes, my lord.
Complaint was before the additional. Page
was-
42 is the page 40.
Page number 35 in the petition, my lord. They have a next page number 35 is my FIR, my lord.
1 January.
So
Hmm?
this FIR, based on this FIR, I of the cases. Page 35, my lord. And extra 2 series in the petition, my lord. And after submission of this report by concerned police station, again I had lodged complaint before ADC Balijan. That is reflected in page number 42 of petition, madam. Page number 42, madam.
What is this?
Page number 42, madam. I similarly have alleged that the petitioner encroached my portion of land and he has to be restrained for further enforcement.
Then it is in the earlier 145 CRPC. Order was passed under 145 CRPC, it appears. Then in that case, because you have,
But my lord, as per order being passed.
then in
by
that
ADC
case, it will
Balijan,
be a criminal.
ADC order being passed by ADC Balijan, my lord, is section 45 of.
In the
Assam-
capacity of what?
Assam Frontier Regulation Act. And also, what is section 44(1) subclause Arunachal Pradesh Civil Courts Act 2022, as per his order now.
No, what is this? The page 10 is execution petition, it appears.
Little bit, Nala, this order is seems to be difficult
See,
to understand.
there is a,
Decree in
it
heading, my
appears
lord,
that it was, the order was passed earlier, 145, but then it says that again, execution petition.
yes, decree. And,
No, there is difficulty. So what we'll do, we'll fix it for admission.
yes.
Some difficulties, you come prepare on that day, okay?
Yes, sir.
My lord, children record from the ADC.
Record is necessary?
Yes. my lord.
Okay, Mr. You are Mr. Lolen, na?
P. Ronia, Your Lordship.
Okay,
Ronia.
Ronia, Land Council for the petitioner. Also had Miss El Hade, Land Election PP for the state, and Mr. N. Rama, Land Council, appearing on behalf of the respondent number 2, staff. Sir, since the parties are duly represented, let this message. After 1 week.
Yes, my
For
lord.
admission.
This is a small matter, my lord.
Okay.
Your Lordship, there's an interim order.
Just a minute, then, so after party present, the council for the party submits that the record of the case would be necessary for proper adjudication case. So, in view of the above, let the record from ADC Balijan,
Yes.
let the record of this case number, this is the one or some other numbers are also there? Because here it says it's execution petition. Execution petition and Barijan PS non-FIR case again.
Yes,
See, mixture of so many things.
difficult to understand, my lord, how ADC.
They only will be able to explain, I think.
Yes,
May you obtain instruction?
and the heading, it seems that decree holder and judgment day. Again, it is confusing.
It is not again under the CRPC also, and this is against the civil also.
Order it seems to be, my lord, mixed up. Civil and
Mixed up, completely mixed up. The record of the case would be necessary, huh? So in view of the, let the record of case number, execution petition Balijan PS non-FIR case number 02/2024 be called for, okay? Yes. Miss Lana additional PP shall also obtain necessary in the instruction. So list this matter after so Balijan, then record if it has to come, then I think will it come
after 2
in a week? After 2 weeks, okay. List this matter after 2 weeks for admission. Okay.
Lordship, interim order, may we
The
continue?
interim order passed earlier, so continue till the next day of listing. Okay.
Oblige. Item number 15.
Yes, what is this about?
Your Lordship, this matter was supposed to list for,
Criminal petition.
yes,
What, the quashing petition or what?
no, this is criminal revision petition.
Okay, this is criminal revision.
Lordship, I am appearing for the respondent number.
You are for respondent number?
2.
2. You are appearing for the first time?
Yes, I have filed for the.
Okay. How many respondents are there?
Here,
Three
the respondent.
3. State, and then you are representing only 2. What about these 3?
He is the victim here.
Okay, you are not representing. Who is 2? Who is 2? 2 is informant.
Yes. No. Two, I am mother
Mother of?
of the info.
Okay, who is informant? Respondent number?
Victim herself.
Marcel,
Victim.
yes.
But you are not representing the victim.
Yes.
Why? You are mother?
Yes, your Lordship, in this case,
You are representing mother, not the daughter.
no, Lordship,
They are independent.
technical issue. Because in this case, I was there as an accused.
Criminal revision.
The learned court below has discharged after perusal of the report and discharged me
Okay.
from the charge.
Then who has challenged this?
So now the petitioner is the accused in the case. He was charged
Charge framed against him.
petitioner.
Let us see the impugn order one. Just where is the impugn order?
Your order is, your Lordship, is case 50.
50, Annex 3.
50.
Yes.
Yes. 2 is the accused. And petitioner is also accused.
Your Lordship, this petitioner, respondent number 2 should not be made party, Lordship, actually. Only victim should be made party in the petition.
But why you have made this mother also as a party, although she was accused, but then has already been discharged. Why you have made party?
Your Lordship, actually, in this case, she is the mother of the victim. That's why we have made the party.
No. She is your mother only.
Yeah.
She has already been discharged by the landed court.
And same, we are challenging the order dated 18 to 2025 that was passed by district and session judge.
Yes, by this 18-2 only,
A
your mother
special
was
judge.
discharged. Why you want to include your mother who has already been discharged? What is your grievance against your mother?
In that case, then we will strike out.
Okay. Hmm. Okay, hard miss. Hard miss.
A-Rai.
Hmm?
A-Rai.
A-Rai, land counsel for the petitioner. You have filed wakalat nama?
Yes, yes.
Hmm.
Today
Okay.
itself, yeah.
Okay. Also hard miss El Hage, land additional 80 for the state. Respondent number, staff. Also, Mr. K. Bosi, land counsel, appearing on behalf of respondent number 2 by filing wakalatnama. Stop, huh? Ms. Rai, land counsel for the petitioner submits that since the respondent number 3.
Two, your lordship.
You are for 2?
And for
Yes. You are for two?
Yes.
Okay.
3 is the victim.
Yes, yes, three. But you are not representing three.
No.
You should represent three instead of two.
I was accused in the case.
But accused,
So there
you
is
were
no
not made
conflict of interest.
accused by your daughter. It was a court who impleaded, because court says, the prosecution says that you facilitated. And that is why you were made accused, not by the victim.
Not by victim, but it was the prosecution who has made me an accused.
Yeah, that is why. Then why should you blame your daughter?
In that case, I can appear you.
Today,
Unless you are authorized, it will be difficult again.
today, Lordship, customer two may be stuck of Lordship, and after next hearing, Lordship, he could
You
appear,
better obtain instruction
Yeah.
from the respondent number 2 and 3. Then since it was not you, it was not your daughter who made you as a party, but it was the state. Okay, now since you have been discharged, now, so if you have no objection, I can represent
Yes.
3. Okay. Okay, then Mr. Posina for the respondent number 2. However, Ms. Rai, Lana Council for the petitioner submits that since the respondent number 2 has already been discharged by the trial court, the name of the her name may be struck off from the array as the respondent number 2 in the petitioner from the course title. Okay. Age break, comma, let the name of the respondent number 2 be struck off from the course title. As course title. Okay. So then whether the amended course title is necessary to file here?
That will be necessary.
I have no idea, because from the middle it will go.
otherwise, I can say.
In
Will
that case,
file-
I will file IA for striking out of respondent number 2.
You better file IA, then
Yes,
we'll
sir.
pass order in that. Okay,
Yes.
then leave this part. Okay. So the record was called for. Proceed for respondent number 2 and none appear. No one appears on behalf of the respondent number 3, huh?
DCR is there, Lordship.
Hmm?
Is there, Lordship.
Yes, LCR is there. Okay. Then you, in the meantime, you obtain instruction and you also file IA for striking of the name. Okay. When do you want?
After 2 weeks.
Okay. Miss Rai, submits that. Miss Rai, praise for allowing her
Your Lordship, there is an interim that may be
2
continued.
weeks time to file IA for striking of the name of the respondent number 2. So upon the prayer allow. Okay. List this matter after 2 weeks. Stop. Huh? The interim order pass earlier shall continue till the next date of listing. Okay.
Actively.
Item number 16.
Your lordships, in this case, fresh step to be taken. And I may be allowed to take fresh step to the sole respondent.
Mr. T. Nega, Learning Council for the appellant. Just a minute. In view of the office note dated 3/9/2025, comma, Mr. E. Nega, Learning Council for the appellant. press for allowing him to take fresh steps upon the respondent number,
Sole
sole
respondent.
respondent. The prayer is allowed.
And I'm allowed to,
How many
Take-
days?
I will be allowed to take the state service also.
Okay. Press step by upon the respondent number, sole respondent by way of the statement. Stop. The prayer
On
is
the
allowed.
last order, there was stating that the interim will be considered in the next date of it. Same may be reflected in this order, so I can take a step.
What is this which order you are impugning? What is the order?
It's a page, impugn order is in page number 30.
Hmm?
This is for criminal appeal, this is. So I'm telling the order of,
Against
pardon, Mel,
appeal against?
against
What
the JMFC order of Namsai.
What
Or-
order was passed?
Order was, basically, we have filed a criminal appeal, a criminal complaint before the JMFC Namsai. Same, it was dismissed by the JMFC.
Your complaint was dismissed.
Yes.
So what interim order you are seeking in the case then? If it was dismissed?
To stay this order
No.
passed by
What
the,
was then? If there is any order survived there, any stay order in that case?
only this order was,
No, interim not required. Yeah. Because your criminal petition case was complaint was dismissed on.
yes,
So there was no any stay order, anything, any order.
no.
Even if it is stay also, what purpose it will serve? We'll hear straight away and then dispose of the matter after considering. You take steps, let them come and let them appear. We'll pass order.
Yes, yes, ma'am.
It's a complaint case.
Yes, complaint case.
So then in this case, not required details, because if it is restored, then fresh notice will have to be issued, fresh summon will have to be issued, isn't it? And thereafter, unless the learned judicial magistrate pass any order, no point.
Okay.
Okay. The prayer is allowed, huh? Steps upon the sole respondent by only by justice service.
No,
The criminal,
yes, criminal appeal.
criminal justice allowed. Who is the accused? It has to be routed through
Yes,
the jurisdictional police station only. Okay?
yes, that will be correct.
Stepped upon the sole respondent by what process? This will not be a register post. You have tried your register post. As well as usual process, whether usual process not yet returned is appear.
Yes.
Oh, you have not yet taken steps.
Your Lordship, I have taken the step.
No, there is no record.
Due to the shifting of the High Court, they have misplaced my,
Then initial step you have to take
yes,
by way of register post as well as by usual process. Not dusty at the moment. Okay?
okay.
Okay. Then in that case, that will change. Mr. In view of the office note dated 3/9/2025. Mr. P. Nega, Lana Council for the appellant submits that although he has taken steps upon the sole respondent, however, during the process of shifting of the court from Vidya to Nahalagan, the record where the record regarding steps upon the respondent where is reported to have misplaced. Therefore, praise for allowing him to take fresh steps upon the sole respondent. Prayer is allowed. Steps upon the sole respondent by a registered post with AG, as well as by usual post a week from today. Stop. This matter after 3 weeks. Of
Obligation.
Matter number 20.
Yes, Mr. Mukbam.
My lord, this is a suction appeal under section 341 of the Indian Succession Act, my lord.
Yeah.
My lord, the brief facts of the case is that Shri
This is for
Gocham.
hearing.
Yes, my lord.
How many respondents?
There are 5 respondents, my lord.
And you are for?
I am for the respondent number 2, 3, and 5.
What about 1 and 4?
My lord, they have been given ample opportunity, my lord, to come before this honorable court. But
Whether the treated is complete?
yes, service has been completed in the month of February itself, my lord. This is the month of
No,
September.
whether has it been reflected in the order?
Yes, my lord.
Where? By which order?
In what? In the order. I'm not certain of the date, my lord, but it's in one of the orders in the month of February, my lord.
So there was in the last occasion probably. Okay, the operation has been stayed. Who are these 1 and 4? Are they necessary party?
They are necessary. 1 is necessary, 4 is not that necessary, my lord. We're not challenging anything
1.
with regard to
You are representing only 2?
2, 3, and 5.
No, the 1.
4 is pro forma respondent. 1 is a necessary party, my lord.
Trial court record we have received.
Yes, my lord.
Then Mr. Patni,
Yes, my lord.
1 would be necessary, 1 and 4 of course maybe, but then 1 would be necessary because he's a.
My lord, 1 has been given ample opportunity, my lord. And what is happening right now?
Okay. Now, 1 respondent, if no one is represent, if the 1 is necessary party,
Yes, my
no
lord.
one represent, what we can do is point 1 legal aid counsel also, but someone has to represent he is a main party, main respondent, isn't it? Someone has to represent the respondent number 1.
My lord,
So
because,
otherwise it will be an ex parte. So
my lord, we can
see,
proceed.
even if we pass an order also, if they come again later on.
My lord, we can proceed ex parte because the respondent number 1 is serving as district tourism officer, my lord. She has enough means
maybe, but then, where is the notice which ensure that he has received?
My
Who
lord,
shows
I have
that-
filed an affidavit, my lord. My lord, I have filed an affidavit,
After serving what, by what?
by registered post, my lord.
Press report
Registered post.
or registered post?
Yes, my lord. And it was shown as
Does it
receipt,
come
my
that
lord.
he himself has received?
Yes, my lord. There is this
Registered post, why you had to file affidavit after registered post?
to bring into records, my lord, that it has been completed, my lord. That the service is
What is
completed.
office on which date?
My lord, this affidavit has been filed on.
Affidavit, okay, but then where is the office note which says that he has received?
My lord, it's on the website, my lord, and this was already appreciated by the coordinate bench, my lord.
Coordinate bench? By which office note it has been reflected that he has received the notice? By which?
My lord, 150, page number 150 of the affidavit, my lord. It's showing clearly that it has been delivered, my lord. Page number 150 of the affidavit, which I have filed, my lord.
Just a minute.
There is the screenshot.
Okay, trial court record we have received.
Yes, my lord.
The operation of the impugn order has been,
Interim order is continuing, my lord.
interim is continuing.
Yes, my lord.
Operation is of the impugn order has been stayed by this.
Yes, my lord. Yes, my lord.
So that is continuing.
Yes,
So
my
what
lord.
we can do is for ends of justice, one last opportunity can be given, recording that the service is complete.
There was recorded in the order dated 0805 2025, my lord.
Yeah. So you have no objection otherwise.
No, Lord. No, sir. We have no objection.
See, this is ex parte only, then in that case,
It can proceed as part of my lord. And it's a very simple point of law, my lord, because
what is this matter otherwise?
my lord, it's a very simple point of law wherein, my lord, the learned trial court has relied on a certificate. Under certificate that was issued by the village, by the relatives of the deceased, my lord. Now, this relative,
What certificate?
my lord, that is annexion number 149, my lord. And this is the only point that has to be dealt
Now,
with.
what is this case about?
My lord, this is a succession appeal, and the entire issue is about who is entitled to receive the debt and securities of the deceased late Gocham
Who
Taga.
are you? Who are you?
I am the wife, my lord. I am the wife.
Okay, who are this respondent number one?
Respondent number one is Gocham.
No, who is he or she?
Sorry, my lord.
Who is he? Respondent number one.
He's the deceased, my lord. He's my husband.
Oh, the respondent number one.
Respondent number one is the alleged second wife, my lord.
Okay, it's the second wife.
Yes, my lord. alleged because and what we have to see, the two questions of we have to deal with in this is whether there was a second marriage, and second whether I was separated from the deceased in the year 2010.
So
I am
the
for the,
deceased was immediately before his death, he was staying with the second wife.
he was staying with the second wife, but he was not married to her. He was having affair with multiple women. That is
Whether you have issues or the children born out of
I
it.
have children, my lord.
Okay, what about the second wife?
No children, my lord.
No children.
Yes, my lord.
Whether she made she claims that she is entitled to.
Yes, my lord. And the court has granted 25% of the debt and securities of the deceased to her, my lord. And I was denied.
What is your advance or claim?
My claim is that I'm entitled to receive the debt and securities of the husband of the deceased.
100%.
Not 100%, 25%, my lord. Because in the lower court, the operative portion is at page number.
Where is the impugn order?
Order is, my lord, annexation number 1.
Page 44. The operative portion.
The operative portion is, my lord, page 44, my lord. Yes. My lord, here it shows para 36, my lord. In view of the above decision arrived upon the foregoing issues, it is ordered that plaintiff number 2, Sri Timi Gocham, son, plaintiff number 3, Sri Saktar Gocham, defendant Srimati Sharing Diki, wife, and mother Srimati Yemi Gocham are entitled to inherit the debt and securities left by late Gocham Taka in equal shares, i.e., that is 25%, my lord. Now, what I have objection is with respect to the 25% that has been given to Srimati Sharing Diki, my lord, the respondent.
Number 1.
Yes, my lord. That is my only objection with regard.
So according to you, she is entitled for how much?
She's not entitled to receive anything, my lord.
No, that is why I'm saying. So that order, this order will go against her only. So
Yes, my
her
lord.
presence would be necessary.
My lord, she has given enough opportunity, my lord. Yeah, and February was the date because I'm being affected currently, my lord. Even because of the interim order that has been given, even my sons are not receiving
So why she was given? Whether her name is there?
No,
Somewhere
her
in
name
the
was not there.
service, the deceased was working.
The deceased
was working in some government.
Yes, my lord.
He was a government employee.
Yes, my lord.
Or whether the name of respondent number 1's name is
No, my lord. No.
not. Then
Sons are there, son.
who filed this succession certificate application for success?
Succession application was filed by me, my lord, by the first.
Okay. Otherwise, this rest 75% is for your family, you and your children. She has been given 25%.
Yes, my lord.
So you have objection to this.
Only the 20% is given to Srimati Sharing Diki.
According to you, she is not entitled.
Yes, I am entitled to it.
No,
So 25%.
you were given.
I have not been given. I am the
But
wife, my lord. But this is Sharing Diki is the respondent here.
This is left you and stayed with the second wife.
No, my lord. There is a disputed fact because we were sharing. We did not leave, my lord. And there is the
okay.
contention.
What we'll do, we'll make it clear that on the next date, if the respondent failed to appear, we'll pass ex parte order on the basis of the records.
Yes, my lord.
Okay.
My lord.
So for ends of justice, last opportunity can be given. Because it will go against straight with it, where it will go against her.
Yes, my lord.
Mr. Mukbang Burton,
Mukbang, B-A-N-G. B-A-N-G, Mukbang.
Mukbang. B-A-N. Mukbang.
Yes, my lord.
Okay, Mr. Mukbang Burton, Land Council for the appellant. So I have also heard Mr.
Ditali.
Land Council appearing on behalf of respondent number 2,
3, and 5.
2, 3, and 5. No one appears on behalf of respondent number 1 and 4. Stop. the order dated 8/5/2025 reflect that service of reflect that the appellant filed an affidavit showing service of notice upon private respondent number it doesn't mention the respondent number 1 and 4 specifically.
But the screenshots are very clear. The service has been
Respondent, huh?
Yeah.
Okay. Respondent. Then the counsel for the appellant submitted fake consignment report, which shows that the notice were delivered upon the private respondent stuff, and accordingly the service upon the private respondents were accepted stuff. In view of the above, the service upon the respondent number 1 and 4 is treated is complete. However, for ends of justice, one last opportunity is given to the private respondent number 1 and 4 to for their appearance. List this matter. Accordingly, list this matter. In view of the above, list this matter after 3 weeks.
No, my lord. On a fixed date, kindly 20 or is possibly 20. 20 of this month is okay.
Or what do we do? This was because not clearly reflecting the name of the 1 and 4.
No.
Can we do
That
one thing that you take fresh steps upon them,
my lord,
and then thereafter finally we'll proceed with?
the distinct are very clear, my lord. It's showing the name is reflected in annexures, my lord.
Okay, okay, okay. Okay. In view of the above, let this matter be listed on when?
28 September.
20?
20 September.
20? 28.
20.
20 is Saturday. 26 September. Huh? 26 September. Okay.